Ladies and gentlemen, please welcome Mr. Robert Spano, partner at Gibson, Dunn and Crutcher LLP, and former president of the European Court of Human Rights.
My message is that what we've been discussing now for a day and a half all boils down to some fundamental thematics which I'm going to be discussing. I'm going to pose two questions to you in the audience, and I want you to reflect on your instinctual answer to my questions. The first is a hypothetical, not so hypothetical unfortunately, but a scenario. A young child commits suicide. The child commits suicide because of its exposure to comments online, comments which reach very deep and trigger a reaction, which unfortunately we see often. Let me give you another example. There is an ongoing excavation in a country in the global south, which has detrimental impact on the natural habitat of its indigenous population. Now, I want to ask you a simple question. Who bears responsibility for this? And are the harms that have just occurred, would you classify them as human rights harms? In the 1950s, the answer to that question would probably have been no, because human rights in the traditional paradigm are rights we have against government. Government is meant to be non-abusive, it's meant to follow the law, and it's meant to not transgress our rights. That has been the traditional paradigm, and it's called the vertical relationship between government and the peoples. If you would ask a business executive in the 1970s, do you have a responsibility in your business to protect human rights? The business executive would probably have simply shrugged and not understood the fundamental basis of the question. And unfortunately, there are business executives still today, naturally, that don't grasp that question. The traditional paradigm between verticality of government and the individual in the field of human rights is shifting to a horizontal relationship between the private sector and individuals. This is what I call the paradigm shift. And there are three reasons this is happening. The first is digitalization. The second is a natural phenomenon called climate change. And the third is the most dangerous development for democracy, especially liberal democracy, which I hope most of us in this room still cherish, which is structural inequality. These three basic shifts, and they all go to what John Rendon was talking about at lunchtime, have supercharged regulation from vertical to horizontal. Because all of the three shifts that I talked about, digitalization, climate change, and structural inequalities, harm or risk fundamental rights and can only be resolved with the cooperation and the full ownership of the corporate community. And that brings me to my third part. How is that being done? Well, it's the abbreviation which this summit is all about. ESG, at its core, is about moving the relationship, which is vertical, into a horizontal relationship of ownership with corporates and the peoples. That's what it's about, ultimately. And the way it is being done at the level of regulation is very ingenious. And I want to take the European Union, which is at the forefront of this. Why do you think most of your companies, at least if you are a member of a big union company or a company that has an establishment or intends or produces in the European Union, Why are these companies now being asked to report on ESG-type metrics? Why do you think that is? Companies have been reporting, especially listed companies, have been reporting for years so as to inform investors. They've been reporting SEC disclosures and classical listed companies, but why are they now being asked to report on environmental sustainability, labor force issues, basic human rights issues? That is because the regulator is moving the pendulum from verticality to horizontality. The reporting exercise, the regulator is asking the company, tell me what you're doing, assess what you're doing from a fundamental rights perspective. Bottom line, because the next step in this continuum is the regulator, when the regulator has seen what you're reporting, the regulator will take the next step. And we see this now with what many of you will know as the CSDDD, the Corporate Sustainability Due Diligence Directive, again in the European Union, which will probably come into force this summer. There, the regulator moves from asking what the company is doing and reporting it to taking that information and saying, now you're going to have to change your business model. Because your business model affects, impacts fundamental rights in ways which are not acceptable. You have to do X, Y, and Z in the way you organize your business. This is a fundamental paradigm shift from verticality of human rights to horizontality of human rights. This is the logic of the business and human rights development. And it is a fast-moving train. And when I talk to C-suites and executives and CEOs, I always tell them, you can take quite a pushback approach and say, it's not for me to reflect on the way in which my business affects other stakeholders than my shareholders. My answer to that is an approach which is not sustainable moving forward because of the big shifts happening in human society. Digitalization, climate change, and structural inequalities. Moving forward, this means, in my view, a radical shift in the way corporate governance models are basically operationalized. It means more and more C-suite executives having ESG either experience or can draw on strong emphasis, whether legal, non-legal, auditing-wise, to be able to meet these requirements. I'm going to be very interested to hear the next panel, which will talk about these issues in more detail. But the future for each and every one of us is a future where human rights no longer is a vertical relationship between government and the individual, but a closely held relationship between businesses and their consumers. Thank you very much.